I'm sure we've all lost someone that we love that is close and dear to us at some point in our lives. Now, the question is, did that loved one leave you any assets? Did they leave you an inheritance? If they did, I'm sure you have questions about what exactly is probate. I am attorney Alina Núñez, and I'm here to speak to you today about the most frequently asked questions that we get regarding a probate process. So the most basic question that we get is, what exactly is probate? Well, probate is a formal or court process by which we have to admit the will of the person who passed away to make sure that their wishes are met, that the assets that they have are given to those that they left named in their will. Well, what happens if they didn't leave a will? That then is determined by the court of who is the rightful heirs of that person. And the distribution is done based on a lot of factors that the court has to consider. That's why it's always important to have your will, because if not, the decision is left in the hands of a judge. So your next question might be, well, is probate always necessary? And the answer to that is, it depends. Most people think that if the person left a will, that they don't need to go to probate because the will says who receives what. That is not true. You have to have that will admitted and go through the process with the court of probate. Now, some situations in which you might not have to do probate is if they left a beneficiary named on a bank account, or if the title to a piece of property was owned with someone else and there was language on there of rights of survivorship. There are very specific situations in which a probate is not necessary. But most of the times, if it's just based that the person died and left a will, you will need to go through a probate process. So the next frequently asked question I get is, how long is this process going to take? And I hate to say it, but I'm going to give you the lawyerly answer. It all depends. There are many factors that go into how long a probate can take. How many assets did the person have? How many beneficiaries? Did they have a will? Is someone fighting that will? Are we able to locate all the beneficiaries? These are all factors that can have a probate take anywhere from 5 to 6 months to over 2 years. Obviously, the more that the beneficiaries are fighting over what grandma left them, the longer it's going to take. So another question I frequently get asked is, do I need to have an attorney in order to open a probate case, or is this something I can do myself? Well, on this question, the answer is not, it depends. The answer is yes. In the state of Florida, you will need an attorney to open up the administration of the estate and guide that person who's going to serve as the representative of the estate through the process. We need to make sure that the proper documents are filed. We need to make sure that the correct steps are taken so you don't have any problems in the future. This is why it's always important to have someone who specializes in this practice area and knows what they're doing on your side. If you're watching this video and you find yourself in this situation where you have lost a loved one, you're already dealing with enough and grieving their loss, call us and we can help you, walk you through this process and help do the administration of the probate. That is what we do. That is what we know. We are here to help you during these difficult times.